sometimes when people are having their Christmas dinner, somebody always forgets something, like they forget the eggs to make the stuffing or whatever. That easily could have been a tragedy for some family. You understand? So obviously, you can't stop drinking. So there's to be absolutely no driving. She's to remain on the GPS device until she's on some type of alcohol monitoring device.
This case hits hard right from the opening line of 3rd DWI on Christmas Day. Let that sink in. While families were sitting down for holiday dinners, this defendant was behind the wheel intoxicated, risking lives on one of the most dangerous driving days of the year. And the judge doesn't sugarcoat it. This isn't about bad luck or misunderstanding, it's about a pattern of behavior that's already reached felony territory. What makes this hearing explosive isn't just the charge itself, but everything that follows: missed deadlines, bond violations, confusion over ignition interlock rules, and a defendant who keeps finding herself one step behind court orders. You'll see how quickly a DWI case stops being about alcohol and starts being about compliance. Because once you're on bond, the rules matter more than excuses. So here's the big question to keep in mind. At what point does the court stop giving chances? Especially when public safety is on the line. Watch how the judge balances accountability, treatment, and protection of the community.
State of Texas versus Patricia Perez. Can I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
Defense.
The judge's opening remarks aren't just rhetorical, they're deliberate. Courts treat holiday DWs differently because the risk multiplies. More cars, more families, more innocent people on the road. A 3rd DWI elevates this from a mistake to a felony because the system already tried warnings, probation, and deterrence, and they didn't work. This is why the judge immediately frames the case around potential tragedy, not just legal procedure. It's a reminder that sentencing isn't abstract. Every impaired driver represents dozens of lives they pass on the road. And when that behavior happens on Christmas, patience runs even thinner. Audience question: should holiday DWs automatically carry harsher consequences, or is consistency more important than symbolism?
And are you Ms. Perez? All right. So there's a motion from the defense to alter and amend conditions of bond. And also I have a violation report. And that is the case in which Judge Angelini doubled the bond. And that was done on April 22nd. All right. So defense, it's your motion.
Thank you, Honor. Can I look at your copy?
Yes. And let's start by addressing the April 22nd doubling of the bond.
So my client posted bonds in this case, and she was ordered to get ignition interlock, and she did. She put it on her vehicle, and then she wrecked her vehicle. Completely wrecked.
So Judge Angelini filed the motion in April, well, at least ordered in April that her bond was doubled.
I think the thing that triggered Judge Angelini signing it was that they had set up a deadline for her to provide documentation to her pretrial officer of the wreck, and Ms. Perez didn't do that. And so I think that's what triggered the second violation report, was that she hadn't provided that documentation to her pretrial officer. And I'm guessing at that point, that's when Angelini signed the warrant and then issued a bench warrant.
It's better. The issue now before the court is, once probation asks you.
Here's where things get technical and dangerous for the defendant. Bond conditions aren't suggestions. When the court orders documentation by a specific date, missing that deadline is treated as a violation, even if the underlying issue is real. The car may have been totaled, but the court didn't have proof when it needed it. That's why the bond was doubled. Judges rely on pretrial services to verify compliance. When communication breaks down, the court assumes risk. This isn't about paperwork, it's about trust. And once that trust erodes, judges tighten control. Important takeaway: courts punish inaction just as seriously as misconduct, if you're on bond. Silence can be just as damaging as a new offense.
Provide documentation of your car being totaled. Did you give it to them? And if not, why not?
Yes, I did, and I emailed it to them, and my husband did also.
What did you email to them?
I emailed them the total loss, and I emailed them that I couldn't get it calibrated, and from the smart start, like the information. There were 3 forms.
All right. So this is what we're going to do. We're going to come back this afternoon. She's going to remain in custody. We're going to call pretrial services to testify by Zoom.
I have something else.
Yes.
Your husband's in the home
Okay.
and he can testify what's in his email.
Okay. So yes, I see him right there. So what we're going to do is we're going to have her come back. So you're not going to go to the Bexar County Jail. What's going to happen is we're going to come back at 1:30 and I'm going to have pretrial services Zoom in. Okay.
Speak up.
Yes, ma'am.
Okay. All right. So that's what we'll do.
Yes.
All right. So deputies, are we able to have her back here at 1:30? Okay. And Norma, can you have the pretrial services officers? All right. For this case. So we are back on the record in NYMAC number 6433337. State of Texas versus Patricia Perez. All right, where we left off, the defendant informed the court that she and her husband emailed documents to pretrial services in regards to the totaling of her vehicle. So we've asked that pretrial services officer come to court, and she is hereby.
Sir Ana Macias from Pretrial Services.
All right, Brenda, are you able to hear?
Yes.
All right, we are here concerning Patricia Perez. Have you been able to pull up the record on that case?
Yes, Your Honor.
All right, with regards to this, the defense's witness, Ms. Perez, and also her husband have informed the court that they sent documentation by email stating that the car has been totaled. Do you have that?
Yes, Your Honor, on April 26th, 22nd, or 2022, Your Honor. I have the claim that I scanned it in, Your Honor, in regards to the 2006 Ford Mustang is total loss.
Okay.
Ms. Macias, what did you say the date was again? I think
I scanned it in her file on April 26th of 2022.
All right.
And I think in the pretrial violation, you submitted a pretrial violation.
This Zoom testimony is a turning point. Pretrial confirms the documentation was eventually received, but after the deadline. That distinction matters. Courts don't just ask if you complied. They ask when. Deadlines exist to manage risk in real time. What saves the defendant here temporarily is that pretrial knew the car was totaled before. Paperwork arrived. That fact prevents immediate revocation, but it doesn't erase the violation. Judges don't rewind time just because. Proof shows up late. Engagement question. Should courts be more flexible when delays are procedural, or does that undermine enforcement entirely?
To the court, a second pretrial violation regarding this issue earlier in April, correct?
Correct. I have it here on April 18th of 2022.
And in that violation, just for clarity of the record, there was a deadline that you had given Ms. Perez earlier to provide you that documentation by a certain deadline, correct?
Correct.
And what was that deadline?
Give me a moment. Let me check. A deadline of April 16th. I made contact on April 14th of 2022 with Ms. Perez, letting her know about the deadline of April 16th. She did tell me that the vehicle's totaled. I asked her for supporting documents.
Okay, so you were aware the vehicle was totaled. You just wanted paper.
Correct.
All right. Any other questions?
None from the state.
Again, all right. Thank you for coming in. Here's the issue we have, Ms. Perez. You were given deadlines and you didn't meet those deadlines. That's why Judge Angelini doubled your bond, because you didn't meet the deadlines. you are on bond for driving while intoxicated, third or more. I'm not accept that as true, that it actually happened, because I haven't received any facts of that. But what I do know is that there are conditions of bond and you need to follow those conditions. So the question is, why did you wait so long? And you're still under oath. Why did you wait so long to provide them documentation when they told you that they needed that documentation April 15th?
I think
When the judge reminds her she's charged with DWI third or more, the tone shifts. This isn't about debating facts, it's about control. At this level, the court assumes the defendant cannot self-regulate. That's why ignition, interlock, SCRAM devices, and GPS monitoring come into play. These tools aren't punishments, they're safeguards. The court's job is to prevent the next offense before it happens. And when alcohol is the recurring factor, monitoring becomes non-negotiable. This is the moment where the court clearly signals one more failure and custody becomes the default.
He gave her till 16.
her deadline was the 16th.
All right, April 16th.
I kept trying to email them, but I wasn't emailing them probably to the correct address or something, but I started emailing right away as soon as I got the paperwork from Smart Start and that. And
Did you pick up the phone and call them and said, I've been
Yes,
trying
I
to
did.
email you?
I did.
All right, State, what are you requesting?
Judge, I mean, I
And she
think,
does have medical issues. I don't know if you're aware of her medical issue.
I don't give, I think that at the minimum, if the court decides to reinstate her bond, I think she just needs to be strongly admonished that it isn't so much, it sounds like she did tell them she was in a wreck, but like the court said, they don't have confirmation until they do. And I don't find it persuasive that she was trying to email their email. I think she just needs to understand that like she needs to communicate with her pretrial officer. And, if she's not able to do that, then obviously her bond could be revoked and she could spend her pretrial period waiting in custody if she's unable to comply with the rules that the court asked and the pretrial asked.
Do you understand that?
Yes, Your Honor.
All right, how did you make it to court today?
My husband.
Did he drive?
Oh, yeah, he was just here in the courtroom.
No. I'm asking her
Oh,
questions.
I'm
Ms. Clark.
sorry.
Yes, ma'am.
Did he drive?
Yes.
Does that car have ignition interlock on it?
No.
That car needs ignition interlock on it. Do you understand?
It says, yes, ma'am.
Is it his work vehicle?
Yeah, it's his work vehicle.
Do you have a new car?
No, I don't. At the time, I
Do
don't.
you have a car?
No, I don't.
Can we put her on the PAN device?
Obviously, he's using his work.
This exchange exposes a common loophole and why judges close it fast. The defendant claims she doesn't drive, but she has access to a vehicle at home legally. That's enough. Courts don't wait for a violation to happen. They remove opportunity. Altogether, that's why the judge orders ignition interlock on any vehicle at the residence. It's strict, but logical. If a third DWI defendant can reach keys, the system has failed. Viewer question, is this reasonable protection or does it unfairly burden family members?
Vehicle, which we learned in law school, which is outside the duties of his work, but he's using his work vehicle to transfer her. Unless this is on a road, on a route to his job, no.
May I say something that
Yes.
I happen to know? He travels extensively. He and I have been in touch with each other.
But he brought her, it doesn't fail the fact that he brought her to court in that vehicle. And he's using it outside his employment duties.
He doesn't really live here much. He's on the road 1 week at a time. He and I coordinated when he could bring her here today because he needs to go back out. He has a company that he runs.
Mhm. But she still has access to the vehicle. Is that vehicle in his name?
It's under his name. Yeah.
Yes. It needs to have
The only thing is she won't be driving it, just him. I just wonder, how do we do this if he's out of town, she's not driving, she's not in the vehicle, who's gonna blow?
no, it's going to be an ignition interlock on that device. And she's also going to be on another device for when she's at home, because I don't know if she's not driving that vehicle or not. It's in his name.
Okay, so he can blow in the vehicle when he's gone on a road trip.
He needs to let them know. I'm sure they'll be able to show that he's not in the county.
They have
But
video on
Yes.
those things.
so that vehicle is going to have ignition interlock on it, and you are going to be on a device as well. Do you understand?
Yes, I do.
You know, and I don't think you know this. I'm court appointed. I don't think they can afford those two things at once.
Well, I mean, the only option she has is to be at the Bear County Jail. Because I can't have her having access to a vehicle.
Yeah, she's
And-
never here.
How about we get a vehicle?
Okay, if she buys a vehicle, which she doesn't have, if she buys one, can the court order it to be on her vehicle so that he can go to work and be free?
No, because it's like every vehicle at the home has to have ignition interlock on it. I mean, that's just the way it is. All right, so what the court is going to order is the court is going to reinstate the bond of $10,000. There should be ignition interlock on any vehicle at the home, and that defendant has access to. And we're going to do scram. And I'll ask that the fees be waived, deferred. You're welcome. If there's any more issues with you not reporting and not doing what needs to be done, we're going to have an issue. You understand?
Reinstating a $10,000 bond here is not leniency, it's structured restraint. The judge adds ignition interlock, SCRAM monitoring, and deferred fees, making freedom conditional and closely supervised. This is the court saying, you're out, but barely. Every added condition narrows the margin for error. One missed report, one device violation, and custody is back on the table. This layered approach shows how courts escalate control without immediately resorting to jail. Key insight: bond isn't about freedom, it's about leverage.
Calling 2022 CR 9288, State of Texas versus Patricia Perez. Could I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Andrew Fraley, Ms. Perez.
All right. Have you had a chance to confer with the state?
Briefly, Your Honor, I was just retained this morning.
Mhm.
And after speaking with my client, finding out we retained knowing she had a warrant, there was a miscommunication about court on Friday. I would like to ask the court to reinstate the bond and provide some evidence
Okay.
as to my client's situation.
I will tell you this, there was no miscommunication. I gave her a setting of when to come back and she did not appear. Twice. So, she's going to go into custody. They will, Ms. Ferguson will have a PR bond done for her. Once I review that PR bond, and since she's in custody, it should be fairly quickly when they get that done. I'll review the PR bond and you all can make your arguments, whether or not a bond should be reinstated or whether or not there should be a bond issued for her.
Sure.
All right.
Thank you.
So, Ms. Ferguson, on Patricia Perez, we need a PR bond evaluation done. Yes, just the criminal history. And I do that because there have been changes, as you know, and that's the quickest way for me to get the case on docket if we do the PR bond. Otherwise, I can have it referred to Judge Carruthers.
Oh, no, Judge, the fastest way would be beneficial. And we
All right.
appreciate that. If there's one thing I could
Yes.
approach the court on the record and introduce this email that I got, letting the court know, just first page is that she successfully completed residential treatment.
Mhm.
Second page is her discharge plan. The third page on here, Judge, lists her medical and mental conditions.
Mhm.
I just want to point out for the court, just so we have it on the record, medical issues, she has a colonoscopy bag, her psychiatric issues, bipolar, schizophrenia, and PTSD. And after speaking with her yesterday and today, I can assure you that the bipolar part is definitely going through a couple of swings. And the schizophrenia, Judge, she has made some numerous statements to me that would lead me to question whether or not she is mentally competent. So we will proceed with those. We'd ask the court in terms of any PR bonds. You wanted to wait for this, didn't you?
Oh, yes, because I don't have anything before me. And what I can tell defense counsel is that as a defense attorney and even as a prosecutor, I would take note of anyone who has any type of mental health issues. And I would always take that in consideration and try to get them help as quickly as possible. However, I cannot have people who are not abiding by the rules of the court. Number one, being reporting to court. Number two, having ignition interlock for DWI third and all of the things that go along with being charged with the DWI third. So we will come back on what date, Ms. Ferguson? All right, so let's bring this back in 2 to 3 days.
I could be here tomorrow, Judge.
Oh, that's not 3 days.
It's ready. I'll call you now.
All right, let's give them a 2-week reset, but if it's ready before then, we'll have her here before then.
Can I ask the court to set a bond today?
No,
So there's no bond set at this time.
no, I don't have any information to set bond. All right, Ms. Ferguson.
October 18th.
All right, so we're going to come back on October 18th at 9 a.m. And
When the judge refuses to set bond later, that's not punishment, it's uncertainty. Without reliable information, courts default to caution. Mental health concerns are acknowledged, but they don't override public safety or compliance failures. This is an important moment. Empathy exists, but it doesn't erase responsibility. Judges can consider mental health and still enforce strict conditions. Both can be true at once. Audience prompt: where should courts draw the line between treatment and accountability?
just check in with Ms. Ferguson in 2 days to see if it's available, because if it's available, we'll put it on the docket immediately.
I'll be here anytime the court needs me to be.
All right. 9288, State of Texas versus Patricia Perez. Can our parties announce for the record for the state,
Marcus Sanders.
for the defense?
Andrew Predick.
And are you Ms. Perez?
Yes, I am, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, sir.
Charged with driving while intoxicated third or more, that's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's no application for deferred adjudication. State recommends community supervision, and there's $60 to DPS for testing. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State.
Yes, Judge.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 3 years. There be a top evaluation, 100 hours of community service restitution, 10 days in the Bexar County Jail, MIC evaluation, DWI.
The plea lays out the stakes clearly, 2 to 10 years possible. But probation is granted with extensive conditions: community service, treatment, interlock, GPS. Alcohol monitoring. This is a comprehensive containment plan. The court isn't guessing anymore. It's building a structure designed to prevent relapse. And the message is blunt: fail this, and prison becomes real, not theoretical. This is the justice system offering one last controlled exit before incarceration.
Intervention, victim impact panel live, ignition interlock for half the term, or alternative for half the term, 2-year Texas driver's license suspension. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No problem.
Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, there's a couple things. In terms of what the agreement was, my client was taken into custody on the, I want to say, day of October, on Tuesday. So we've asked if we can give her that credit for the 10 days since the 4th day of October. We believe that exceeds that number. As far as ignition interlock, Your Honor, we'd ask that that be a portable alcohol monitoring device. So because she does not own or operate a motor vehicle, we have to be taken into consideration the fact that she did a month of inpatient treatment. Not saying she doesn't need more treatment, but we ask that you take that into consideration that she has taken the initiative. Finally, Your Honor, we ask you to follow the orders. Oh, one more thing. At this time, Judge, my client lives and resides in Kendall County, Texas. We believe that might be the best place to do supervision.
Are you employed?
No, I'm not.
How you support yourself?
My husband has one baby.
Do you have any children?
None,
Any grandchildren?
none.
All right, this is what the court is going to do. Court is going to sentence you to 2 years in prison, suspended and probated for 3 years, $60 to DPS for testing, 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Ignition interlock for half the term. We've been down this road before. Her husband has a vehicle. He doesn't have a vehicle. It works. It doesn't work, but she is going to interlock on any vehicles at that home. VIP live. There's to be a MIC evaluation that can be done out of custody. DWI intervention. Intensive outpatient treatment with probation, sober meetings 1 time per week. There's to be a transfer to Kendall County, proof of employment within 30 days. There's to be no employment as a home healthcare provider with minors, regular reporting by Zoom or in person. And you can either do 10 days in the Bexar County Jail, or she will be on GPS for 30 days. And that's full GPS for 30 days. Which would you prefer?
Judge, will you give her credit for the time that she's been in custody? So if
No.
that 2 days would start now.
Yes.
I'll do the GPS.
All right, so there's to be full GPS for 30 days. All right, is there anything else that you need?
No.
All right, we can go off the record. So you were driving intoxicated on Christmas. Sometimes when people are having their Christmas dinner, somebody always forgets something, like they forget the eggs to make the stuffing or whatever. That easily could have been a tragedy for some family. You understand? So obviously you can't stop drinking. So there's to be absolutely no driving, of course, while your license is suspended, because it's suspended for 2 years. And you need to make sure that you have that ignition interlock, and that's any vehicle at that home. You understand?
Yes, Mom.
All right, Ms. Abrams, on this case with Ms. Pettit.
The judge circles back to Christmas for a reason. It's not shaming its emphasis. This case represents the risk of unchecked behavior. The warning is unmistakable. No driving, full monitoring, and zero tolerance. Every condition now exists. Because prior chances were wasted, the court has done escalating intervention step by step. What comes next depends entirely on compliance. This is the final off-ramp.
Yes, do you think it's that she be transferred to Kendall County?
Yes, Your Honor.
All right, so even though you're going to be transferred to Kendall County, what will end up happening if you don't follow the rules there? A motion to revoke will end up being filed and it'll come back to the court. You understand?
Oh, definitely.
All right, so do you have plans in place so you can be successful?
Yes, ma'am.
Okay. Probation, how is she being monitored with regards to any alcohol use?
Let me double check, Your Honor.
Are you on any type of device for alcohol testing?
Well, no, I don't know if this is, remember, I was really supposed to have this for a month, but I've had it for like 120 days now.
Oh, yeah. I mean, the reason why you've had it for that time is because you have not been following the court's rules. So is she on any type of alcohol monitoring?
I'll be there.
Because she was the person who had some issues with a vehicle at her house. It was her ex-husband, maybe not her ex-husband. Because I had on here ignition interlock for half the time. All right, so she needs to, if she's going to be supervised in Kendall County, she either needs a portable device, but she needs a alcohol monitoring device. Yes, so I want her in that sober device then.
Okay.
All right, is there anything else?
Did you want her to remain with the GPS?
Is she able to remain with GPS and be in Kendall County?
Yes, Your Honor. I mean, it's the.
All right, so she's to remain on the GPS device until she's on some type of alcohol monitoring device. Anything else you need from the court?
No, I'm not.
Let's close this out clearly. This case wasn't decided by a single bad decision. It was shaped by patterns. A third DWI on Christmas, missed deadlines, bond violations, and inconsistent compliance forced the court to escalate control at every stage. The final ruling balanced treatment, monitoring, and public safety but left zero room for error. The broader lesson is simple. Courts forgive mistakes, not patterns. When warnings stack up, freedom shrinks. Now we want to hear from you. Did the judge strike the right balance, or should custody have come sooner? If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments. And don't forget to subscribe our channel for more jaw-dropping courtroom breakdowns.